Welcome back to Unfair Housing. I'm Alicia Magazoo, and with me today is Nicole Carrero, along with a very special guest. We are thrilled to welcome a nationally renowned fair housing attorney with a wealth of knowledge on civil rights matters, Mr. John Relman. John is a founding partner of the civil rights law firm Relman Colfax. He's worked on several groundbreaking cases protecting civil rights, from suing Denny's for discriminating against minority customers to bringing the first predatory lending case that established reverse redlining as a cause of action, which is something we'll touch on today. John is also published. He wrote the Housing Discrimination Practice Manual, so for all our civil rights activists out there, be sure to check that out. John has been deservedly recognized for his contributions to civil rights and the fight for equity. John has been named a super lawyer several times and was named one of Washingtonians' best civil rights lawyers, both nationally and in Washington, D.C. John, welcome to the show. We're so glad to have you here.
It's a pleasure to be here. Thank you for having me.
And before we get into the substance, I'd kind of like to get a little bit of background on you and kind of let our listeners know. We know how great you are here on the show, but for the listeners who may not be as familiar with you, if you could talk us through your career, what got you into civil rights, and kind of what your highlights are in working in this area of law.
Sure. Well, I went to law school with the idea of wanting to be working in the area of social justice and be a lawyer who dealt with social justice issues. And probably the seminal moment for me was a summer job that I had in law school where I was working for the NAACP Legal Defense Fund. And I went down to Alabama and Mississippi. We were working on voting rights cases and employment discrimination matters. And after that summer, I was just done. That was what I wanted to do. It was the work that I thought was the most significant, most important that anybody could be involved in. And I went on to do what I could to take a position and do that. And so when I finished law school, I clerked for a little bit, and then the first job I took was with the National Lawyers Committee for Civil Rights, and I started out my career as a civil rights litigator.
Wow, that's really something to hear that it sounds like you knew even as early as law school that that's what you wanted to do. And certainly you've done that. So to that end, as Alicia mentioned at the top of the show, we'd like to talk about the legal concept of reverse redlining. So in several of our previous episodes, we've focused on the history of housing segregation. We've discussed how redlining was used to separate Black and white neighborhoods and deny loans to Black borrowers. So just to remind our listeners, the Homeowners Loan Corporation was established as part of the New Deal programs designed to help the country recover from the Great Depression. That agency, with a lot of influence from realtors, established maps that marked areas by their perceived level of risk. And that resulted in maps with Black neighborhoods marked in red where lenders could not lend. The Federal Housing Administration would also not insure loans made in those red line neighborhoods, a position that the Veterans Affairs Administration followed as well. Now, while we've talked about redlining in a historical context, we don't want to give the impression that redlining is not an issue anymore, or that the Fair Housing Act has eliminated its practice. While the act, of course, makes it illegal to redline based on a protected class basis, as we've discussed many times in previous episodes, passing a law unfortunately does not alone eliminate the practice. So, John, could you tell us what redlining activity you've seen throughout your career and what redlining looks like today?
Sure. So, I mean, redlining is the practice of us literally drawing a red line around a minority neighborhood, typically a Black or Hispanic neighborhood, and saying we're not going to loan to that area because we don't think that folks in that neighborhood are likely to be qualified for the loans that we're going to make. And usually, redlining refers to a practice of making that decision because of the race of the people who are in that neighborhood. And typically, it's denying them access to what we call a prime or a good product. And this practice has been going on, as you've mentioned, with the Homeowners Loan Corporation. It was government sanctioned going way back to the 1930s. But even after that government sanctioned practice ended, redlining was going to continue to go on throughout the country in communities both in the north and the south, the east and the west, and cities across the country by private actors, by financial institutions of all different kinds. Um, and and this really came to the fore for me starting in the early 1990s. I was, early in my practice at that time. I was with the Washington Lawyers Committee for Civil Rights. I was directing their fair housing project. And the Justice Department had just started to focus on this issue for the first time. This was under the Clinton administration. And there were a couple of cases that were really seminal. And one of them was right here in DC, where my practice is based. And it involved a bank called Chevy Chase Bank. And they identified neighborhoods in DC, the nation's capital, where this bank drew circles around the neighborhoods, and they identified through the investigation they had done that there were instructions to the employees: do not loan in those neighborhoods because of the race of the people who live there. And so they literally had essentially their own sort of homeowners loan corporation map from the 1930s that they were applying to use in DC. And at that same time, there were experts who were working with the Justice Department who were starting to develop statistical analyses to determine from looking at the statistics who was getting loans and who wasn't. So they could marry up both what we call this anecdotal evidence, or the testimony of people about what they were told to do, with what the data showed about who was getting loans and who wasn't. And they started to look at things like income levels and credit scores, and determining that folks who were Black or Hispanic with equally good credit scores, or in the same income categories as folks who were white, were not getting the loans, and folks who were white were getting those same loans. And so it was a marrying up of these two types of evidence. We at the Lawyers Committee, we brought a case that was sort of based on this Justice Department investigation framework against Nations Bank as a class action in the 90s. And that was really one of the first private class actions that was being brought by civil rights litigators in what I call this modern era. Ever since then, I have been aware of and involved in redlining cases that we have identified all across the country with client organizations that have done it based on both this combination of what we call anecdotal evidence, testimony of ex-employees in some cases, and a heavy emphasis on statistical analysis, where we are looking at neighborhoods that we know have plenty of qualified home buyers, and yet no loans are going in that area. And so two other things that have helped this investigation of redlining cases to mature and to accelerate since the 90s is the availability of this, what's called Home Mortgage Disclosure Act data. This was a law that was passed in the late 70s, and it has been improved with more rigorous requirements about the information about loans that has to be made public, that private financial institutions have to give to the government, and that tells the public who's getting loans and what are the qualifications of those borrowers. So you can start to see if there are patterns in banks that have big disparities in the numbers of folks who are Black or Hispanic are getting loans and have indicia of being qualified compared to whites. And at the same time, the Justice Department has improved on its template that it uses to investigate banks. And it looks at, for example, what does the bank defined as the area that it says when it reports to federal agencies is its area of doing business, and then sees where are they making loans. They also look at where branches are located, which is very, very important. Where branches have been closed, what's the pattern in terms of where loans are going in the past and where they're going now. And so, and all of that is very important in figuring out where the government wants to open an investigation, and also where we as private actors, as private civil rights lawyers, where we open investigations and potentially bring cases. But redlining is something that has continued to go on. And I would say it's as prevalent now as it has ever been. And to that end, under the Biden administration, the government filed and won a record number of redlining settlements or verdicts, mostly settlements, in just the last 4 years. It gives you an idea about the prevalence of redlining and its continued its continued existence long after the Homeowners Loan Corporation has disappeared.
Absolutely. And to that point, considering that the act is initially passed in 1968 and it's in the 90s where you're describing this activity of the Justice Department taking notice, and looking at, I like how you describe the marriage of statistical and anecdotal evidence and looking at both, as well as those areas of doing businesses where branches are located, closed. Is there a pattern? So it doesn't, unfortunately, not very surprising that you still see it as very prevalent. Along those same lines, I think it's fairly intuitive or easy to understand the concept of redlining. Can you tell us a little bit more about this concept of reverse redlining and the case where you argued that legal theory for the first time?
Sure. So, reverse redlining, we like to say, is the flip side of the same coin as redlining. We think about it this way. Redlining is a practice of drawing a circle around a neighborhood and not making a good product available to that neighborhood because of the race of the folks who live there. Reverse redlining is just the opposite. It is targeting that neighborhood because people who are Black or Hispanic live there, to give them a predatory or a bad product, to sort of peddle poison in one shape or form or another. Why is that done? Because many times predatory products can make a company a lot of money, and by exploiting people. And reverse redlining, we could quickly see after the focus came on redlining itself, the reverse redlining became immediately evident, even though it's been going on for a long time. It became immediately evident because of the connection between the two practices. That is, that in the neighborhoods where communities had been historically denied the opportunity to get a good product, it opened up, it created the opportunity for predatory lenders to come in and say to people who are desperate for a credit product, who have never heard the yes answer, you can have a loan, to suddenly get a loan, and being very desperate to get access to loans. Folks in these neighborhoods who, by the way, did not have access to good advice. There was not a structure of a branch being there to tell them, hey, that's not a good product. You could qualify for a better product with the credit score that you have or with the income you have. They didn't have access to those networks. Those advisors in reputable banks were in the white neighborhoods. So in these areas that were like deserts when it came to the availability of good loans and access to good advice, they were vulnerable to these practices. And so folks went in there and started to prey on those communities. And actually, that practice has been going on for some time with something called land contracts, which was a practice that went way back to the days of the Homeowners Loan Corporation, where unscrupulous sellers and financial institutions would come into Black neighborhoods that had been redlined. They would buy up properties, and then they would engage in predatory practices. The land contract was a typical predatory practice. It was one where folks were deceived into believing they were getting a loan, but actually they were just getting essentially a rental contract, and they did not own the property until they had made payments on what would be usurious rates, interest rates for 30, 40, 50 years. So they would not have equity in the property. They could be evicted at any time. And that was one form of predatory practice. In the modern era, and we can talk a little bit about um, how reverse redlining came about in modern times, starting around the end of the 90s, beginning of 2000. But in the modern time, the practice has been actually quite similar. The predatory practice has been about charging usurious rates or very high interest rates, and then either forcing a property into foreclosure and buying that property from the person who's had to give it up at a very low price and then flipping that property or selling it. Or another practice has been charging usurious rates or very high interest rates, and making money at the time of closing with fees and points, and then selling that risk of that loan to a secondary market player. And we can talk more about how that works, but these practices, let's say there was a resurgence of this predatory practice and this targeting of minority communities that we really identified starting around the early 2000s.
It's really fascinating that you're bringing up all these points because we have an episode on land sales or contract sales and addressed a lot of these same things, and it's so interesting to hear you bring this up and talk about how important the data collection is and the inclusion of HMDA. And so just to remind our listeners, we kind of tease this idea, and back in those cases that were decided in the very early 70s dealing with the contract or the Buyers League in Chicago, they excluded a lot of that really important data from the arguments that they were trying to make in those cases. So it's so interesting to kind of see that change over time and just how important those cases were to bringing attention to that data, and the ability to now use that data to make arguments is just really, really fascinating to me. How have you had a lot of case experience where you've been able to present that data and come out with favorable decisions for your clients?
Yes, and the data, that statistical data, is absolutely critical, and it's worth sort of explaining a little bit why. When you have a case that involves an individual borrower, and that borrower says, let's say the borrower is Black, and the borrower says, I think I was qualified, I should have gotten the loan, and I think the issue is discrimination. It is very, very difficult to prove that claim based on that evidence alone, unlike in a housing transaction, for example, where there can be evidence of testers, for example, who have gone in and shown that, a Black tester was told that housing was unavailable and a white tester was told housing was available. And that backs up what an individual housing applicant says about discrimination. In the lending context, you can't do that. And so it's very difficult to establish the intent to discriminate on the basis of race. For any individual case, it's almost always the case that a lender can come up with some explanation, some potential reason for why someone didn't get a loan. You were late twice on your credit card. You didn't have enough income in X month. your credit score was only X and we take Y. And unless you know what that lender did with other borrowers and you can see a pattern, it's very difficult to prove that the decision wasn't just based on strict standards as opposed to discrimination. I can give you a good example. One of the first cases that I had at the Washington Lawyers Committee was a case involving a professor of law at Howard University Law School. His name was Spencer Boyer. And we took on the case. He came to us and he had applied for a loan, a refinance loan on his house. And he went to a bank. It was called First Virginia Bank of Maryland, believe it or not, First Virginia Bank of Maryland. And he went in and you know, it's interesting. He said, look, I'm a tenured professor at Howard Law School. I have over $400,000 of equity in my house. I'd like to take out a refinance loan of $50,000 because my daughter is going to Stanford Law School and I'd like to borrow that money to pay tuition. And the individual branch manager who was there, a gentleman by name of Mr. Grippo, said to Professor Boyer, he said, you know, look, we'll take a look at it. And Professor Boyer, when he came to our office, told me, he said, I knew right then I just wasn't going to get that loan. I just had the feeling in my bones. Sure enough, a couple of weeks later, he gets a rejection letter from the First Virginia Bank of Maryland. And under certain laws, you have to give the reason why, banks have to give the reason why someone was turned down. And this bank, the reason they gave was they said it was because he had 3 or 4 late payments on his credit card. You know, he had paid, but instead of paying within 30 days, he had paid 45 days and he was 15 days late. And he looked at me, he said, you know, I said, why were you late on those payments? And he said, I don't know, I was traveling. I can't know, but I paid them. And he
Wow.
said, I can't believe I got turned down for this. He said, do I have a case? And I said, Professor Boyer, look, if this is an equal opportunity stupid lender and they're going to turn somebody down for 3 30-day late payments when you've got the credentials that you have, then they may just be a bad lender in the sense of they're not making smart business decision. But if they treated white applicants who had 3 late payments differently than they treated you, then we have a case of potential discrimination. And fast forward with this story, it was critical that we get into discovery and that we find out, we get essentially that statistical evidence. And in this case, it was getting all of the files of people within a certain period of time so that we could look through them and see who had 30-day late payments. And believe it or not, we had to fight. The bank fought us. We won the right to get into the bank's files for a 2-year period. And we found literally scores of applicants who had not just 3 or 4 30-day late payments, but 20, 30, 40 late payments, were white, and had dealt with Mr. Grippo. And when we called those folks to investigate, we said we were calling to investigate a potential claim of discrimination. We said, what was your experience like with Mr. Grippo? I said, oh, Mr. Grippo was great. He helped us out. Said, don't worry about the late payments. There's lots of other stuff here that we can use to qualify you for a loan.
Wow.
And that became what the Justice Department called the thick file, thin file syndrome, which was what they spotted was that for white borrowers, when they got into the files, just as we had done, they found that the files of the white borrowers were thick, meaning there was lots of correspondence, lots of back and forth. We've noticed this, but can you give us additional information that would help you to qualify, trying to help the borrower through. For Black borrowers, the file would be thin. There would be nothing there. It would be just like Professor Boyer's. Came in, asked, they looked up something, immediately found a reason to turn them down, and that was the end of the story. We ended up bringing a lawsuit against First Virginia Bank, and the case settled for close to $400,000. So, I mean, that really shows the importance of this statistical evidence and the Home Mortgage Disclosure Act. What it essentially does is it provides now detailed information about who and where the banks are lending to, the race of the person, because the bank is required under this law where they can identify the person's race to put it down, or where the person self-discloses to put it down. And it allows us to get a window on what they're doing without having to fight to get into the files. And where we see that banks are outliers, and that typically is the measure. We will look at Home Mortgage Disclosure Act data for a metropolitan area, a city like Philadelphia, or we'll look in multiple cities at where a bank operates. And if that bank has what we call a denial disparity rate, that is the ratio between whites and blacks that they turn down, that ratio, which typically usually favors whites, and that may be just in part because of the historic wealth gap that we have in this country, but nevertheless, where we see a bank is an outlier, like they are way behind what other banks are doing in that community, that can be a telltale sign that something is going on. And then we combine that with looking at where their branch is located. What do they say is their area of business that they do in? And when we look at the pattern, when we map where the loans are going, do we see that the loans are all concentrated in white neighborhoods and none are in black neighborhoods? And when we compare those, what we call dot density maps, with other banks and see that those other banks have lots of dots in black neighborhoods where the target bank has no dots, we start to ask questions like, wait a minute, why is it that your peers can find qualified home buyers in these black neighborhoods and you can't? What's going on there? And it's that statistical evidence that gets us beyond the excuse, which is, yeah, in this one case, they can pick it apart and find a reason why you weren't perfect and therefore you didn't get the loan. But as I say, that doesn't allow you to show the pattern. And in discrimination cases, when you want to show intent, showing that pattern is really critical.
We'll break here for today and finish our discussion with John next week, when we'll focus on modern-day contract sales practices and other predatory practices that stripped wealth from Black Americans and the impact those practices had on Black communities. Remember, if you or someone you know is experiencing housing discrimination, or if you would like to schedule a fair housing training, contact our Fair Housing Unit at 800-875-8785. To see if you qualify for other legal assistance, contact the CLS helpline at 800-405-1417. And if you enjoy the show, give us a like and a follow, and please share the series with your friends and family. Also be sure to follow CLS on Instagram, Facebook, and LinkedIn.
The work that provided the basis of this publication was supported by funding under a grant with the U.S. Department of Housing and Urban Development. The substance and findings of the work are dedicated to the public. The author and publisher are solely responsible for the accuracy of the statements and interpretations contained in this publication. Such interpretations do not necessarily reflect the views of the federal government.